You and your spouse have accumulated a lot of wealth over the course of your lifetimes together. And you've got all the stuff. It looks beautiful from the outside. You have the houses and the boats and the cars and you can pay for all the ballet lessons and the soccer tournaments and dance camp and competitive tennis, competitive equestrian events, what have you. So how's all that money gonna help in the custody situation, in dealing with time sharing and parental responsibility issues? Does the higher earning spouse, the one that really has all the wealth, have an advantage because they can better provide for the children over the spouse that earns less or doesn't have any wealth in their own name? And the answer is no. There is no benefit or value to having wealth with respect to how much time you're going to spend with the kids. That's just not something that is a consideration by the court in the majority of situations. Why doesn't it matter? It doesn't matter because kids need parents. That's it. They need both of you. They need loving homes. It doesn't matter where that home is or how much money is in the bank account of that particular co-parent. What does matter is that each parent is focused on the best interests of the children, period. Let's say you're getting a divorce and your kids, who are amazing and they are overachievers, they're involved in everything. They are involved in football and soccer and baseball and cheer camp and competitive dance, all of the things, piano lessons, horseback riding lessons, all the stuff. They have every single advantage that anyone could want. I would want that. What happens to all that? They go to private school. What happens to that? So let's say you have enough with your aggregate salaries to continue to pay for all those things for your kids plus the private school. But what happens when the parent who, let's say, has majority time sharing during the school week can't afford to send the children to the private school any longer, or the other parent no longer agrees to send the child to private school? Or what happens if all of a sudden the parent who may be the higher earner and may be responsible for child support doesn't want your children to be involved in all those extracurricular activities that sounded like a good idea when you were married? Well, the fact of the matter is that there are situations where the private school may have to go. We don't know. We won't know until we see how this plays out. But certainly, if you have shared parental responsibility, meaning decision-making authority over things like education, e.g. private school, then if one of you doesn't agree, unfortunately, that falls apart because shared parental responsibility means shared. You have to come to an agreement, unless your marital settlement agreement and your parenting plan say something else. Again, with respect to extracurricular activities, there may be a provision that you put into your parenting plan. As for extracurricular activities, they may or may not continue. In your parenting plan, you probably are going to put in a provision that says, hey, we have shared parental responsibility, and because of that, we have to agree on extracurriculars and how we're going to pay for them. If we don't agree and the other parent continues to put the child or children in extracurricular activities that the other parent didn't consent to, that parent has to pay for 100% of it. That's kind of a typical provision. So the answer on if private school and extracurriculars are going to continue is maybe. And it kind of depends on you and your finances and your tolerance. So let's say you are in one of these situations where your kids have had every advantage. That you do have some familial wealth, some wealth that you've accumulated through the course of your businesses or careers, so that you've been able to give your kids just everything. And part of that everything is that someone was also home at some point to run them around to all the things in which they are involved, to make sure that the homework got done for all those AP classes and the extra tutoring, etc. So what happens now when we're looking at taking these things away? I mean, how can that possibly be in the best interest of the children? Well, the way that we look at that in this situation is the same way the court analyzes it in any other situation. We look at the statute that governs the best interest of the child. There are 20 factors. We look at, if we take this child out of private school or leave them in, is it in that child's best interest? Meaning, we go through 1, 2, 3, 4, we go through all 20 of those factors and see, is this the right thing for this child? Yes or no? Nothing more, nothing less. No one ever died of not having horseback riding lessons. So let's say you're the high earning spouse and you are walking away from this with a ton of money, and your spouse was the partner that did not earn as much and is walking away with not much. You can afford to keep sending the kids to private school. You can afford to keep them in, extracurricular activities, etc. Is that ability to continue to fund that life for your children going to have sway over a judge if your case goes to trial, meaning you're going to get more time with the kids and she's going to get less because you've got the money and you've got the ability to give them the life? The answer is no, probably not. The judges, by statute, still have to look at the best interests of the children. There may be a judge that agrees with you and thinks that's phenomenal. Guess what? They're still bound by the law, which is the 20 factors in the statute that determine whether or not that's in the best interest of the children. Is it, if the other spouse can't provide those things for the children and you can, it doesn't mean you're going to get more time. It doesn't mean you're going to get your way. It means that you've got to show the court on the date of your final hearing, when you're presenting evidence, that what you want to do with respect to the time sharing plan that you want, the way that you want the parenting plan to come out, is actually in the best interest of the children, and you need to present evidence of that beyond your bank account. If you have questions about how your monetary position might affect your custody issues in your Florida divorce, give Brava Law a call. We'll talk to you about it.